format doesn't really allow us to pick up a lot of the things that you mentioned in this, but know that we are reading your submissions with great interest, and we may follow up with additional questions. I would like to point out for everyone that the committee has actually agreed to convene at the end of this year's 301 review cycle to do exactly what you've asked, which is take a top to bottom look at the special 301 process, and we plan to publish a Federal Register notice, solicit public input. So from any interested stakeholders are welcome to do that. Watch for that sometime in the late spring, early summer. So I know several people have asked on both sides of the aisle, so to speak, for us to take a look at the process, and we are going to do that this year.
I think that would be great, and a lot more time for questions would be super, so we could have these kind of discussions on the record.
Sure. Thank you very much. I'd like to call the next witness, Biotechnology Industry Organization. Welcome. Thank you for joining us today. Please introduce yourselves and spell your names. Thank you.
I'll start first. My name is Leela Faizi, and I'm the Vice President for International Affairs at Bio, and my name is spelled L-I-L-A-F-E-I-S-E-E.
Roy Zwallen, also with Bio, R-O-Y, last name is Z-W-A-H-L-E-N.
Thank you very much. As I said, my name is Leela Faizi, Vice President for International Affairs at the Biotechnology Industry Organization. Today, I'm testifying on behalf of Bio and its 1,100 members who innovate in the healthcare, agriculture, and industrial and environmental sectors. The vast majority of our members are small and medium-sized enterprises with no products on the market currently. And with no source of product revenue and long development times before market launch, biotechnology companies must leverage the strength of their global patent portfolio to raise the large amounts of capital that's required to get their innovations to the market. In this global economy, where investment decisions often include the growth of potential in emerging markets, IP setbacks like as in places like in China, India, and Brazil, can have a significant impact on the delivery of scientific progress, the availability of the next generation of biotech innovation, and on its ability to create jobs here in the United States. These IP setbacks are outlined in our written submission in much more detail, but my testimony today will focus on the areas of most concern. In contrast to 20 years ago, the global intellectual property environment is viewed to be deteriorating in many countries around the world to standards that harm innovation everywhere. Some of the deterioration has been more subtle, such as requiring unnecessary information in patent applications for certain technologies in places like China and in Canada. Some deterioration has been more dramatic, as countries like India institute a pattern of seeming unconcern for broad areas of intellectual property, no matter what the impact on local or global innovators. While BIO's members expressed concerns about many countries in our special 301 submission, we thought it best to spend our limited time on our recommendation to name India as a priority foreign country. In the healthcare space, only a few dozen innovative and patent-protected medicines are on the market in India. Yet, in the last 2 years, more than a dozen patents have been revoked, compulsory licensed, or threatened to be compulsory licensed, or otherwise rendered unenforceable. In addition, several biotechnology inventions in the health and agricultural fields have been denied patent protection. These same products have been granted patents in many other jurisdictions around the world. There are perhaps other anti-IP actions that we just don't know about yet. The fact that these same patents are valid around the world in both major and emerging markets reveals a clear lack of concern for protecting innovators in India, presumably for the benefit of India's industry. The Indian government claims that it is taking these steps to keep prices of medicines and improve access to medicines, especially in the pharmaceutical sector. However, we contend that these actions are in reality a form of industrial policy designed to improve local commercial interests at the expense of U.S. biotechnology companies. These steps by the Indian government benefit in a very tangible manner its domestic pharmaceutical industry. The medicines being targeted, such as Bayer's Nexavar, Pfizer's Sutent, BMS's Sprycel, Roche's Tarceva, and Novartis's Gleevec, are highly specialized anti-cancer medicines that benefit a small fraction of India's patient population, and only those who can already afford the highly specialized medical talent and facilities to properly diagnose and treat the relevant forms of cancer. Yet, to our knowledge, only one of these medicines, Gleevec, appears on India's national list of essential medicines list. No amount of patent revocations, compulsory licenses, enhanced efficacy requirements, or other methods to render patent rights unenforceable will address any of the systematic healthcare problems that are plaguing India today. The real tragedy underlying the anti-IP rhetoric is not simply that it diverts attention away from the real problems of access to healthcare that many millions of Indians face, but that it undermines India's goal of becoming a healthcare and science innovator. There are companies around the world interested in collaborating in research, science, and development of medicines in India. These measures make it difficult and often impossible for such deals to happen. In our view, this is a problem for innovators in India, as the deals will simply go to other countries with more respect for IP rights. Nonetheless, a number of our member companies continue to strive to be successful and to help the Indian poor through patient assistance programs which provide the medicines for free or even below generic price to the poor. There are creative licensing strategies to allow Indian generic companies to manufacture medicines to reduce costs, technology improvements to enhance storage life of medicines to survive the lack of infrastructure in India, and many more initiatives that contribute to addressing the healthcare burden in India. Yet, American companies cannot fix this problem alone, and the current set of IP policies impedes them from doing more. The government of India spends around 1% of the country's GDP on healthcare. That is lower than all other emerging economies and even lower than several heavily indebted nations. India's vast economic growth over the last decade has clearly not been matched by an equivalent increase in public spending by the government. While it may not be our place to set priorities for the Indian government, we wish to point out that both the significant costs of its current approach in undermining its potential as a global biotech innovator, and we also wish to observe that the benefits to healthcare in India, to the extent that they exist at all, would not appear to offset these costs. Perhaps of greater concern to us is that if India is left unchecked and is successful in its efforts to weaken its IP laws to benefit its local industry, it will not be an outlier in its policies, but other countries, emerging and middle-income countries, will follow suit, creating a significant burden on the U.S. economy. This is not sustainable, especially in view of the current economic environment in the U.S. Upholding the system of intellectual property rights is essential to guaranteeing future innovation and future jobs, not just for U.S. biotechnology companies, but also for other countries and other industries around the world. Thank you for this opportunity.
Thank you very much for your testimony. We do have several questions. I would like to lead off by repeating some of the questions that we asked a little bit earlier of AFT, 3 in particular. You did touch on some of the investment decisions that are being made by your member companies in response to some of the policies that are coming to the forefront in India. Can you elaborate on those either today or in a post-hearing submission, generally speaking, but also with respect to its impact on the U.S. jobs and the U.S. economy, and also impact on public health? And then I'd like to also pick up the question that Commerce asked AFTI, which is, how difficult is it for your businesses to engage with the Indian government? Are you having any success? Are you able to have the conversations that need to be had? Are the procedures open and transparent? How are your companies finding the engagement with the Indian government, please?
Thank you very much for the question. So in terms of investment decisions, I can't say, because we're an association, we hear various companies and some of their concerns, but in terms of investment decisions, what we have experienced is that our organization has been a convener of meetings and conferences to enable the Western companies or multinational companies and even small and medium-sized companies in the US and in Europe to go to India at our Bio-India conference that was held annually for 3 years in a row to actually do partnering. We have partnering softwares that allow our companies to meet with innovators in other countries and do partnering deals and research and development and contract out research. And we did that for 3 years in a row. But last year, we were not able to get any companies from either the US or anywhere in Europe to want to go to India to actually do these deals. So in terms of investment, I can't say for sure, but it seems to me that there is conscious decision being made to, look to other areas potentially to do deals. Now, with respect to what it does for healthcare or investment in India, obviously, if the deals are going to other places or to other countries, that's potentially a problem. But also, India has amazing research institutions, amazing universities that are doing a lot of cutting-edge research. The problem is that if there is unpredictability in their IP systems, and if it's difficult to protect those those innovations, then it's very difficult to actually develop or translate those discoveries into tangible products. So if the research in India is being done in the area of healthcare, which I know that there are several of the institutions that are working in that area, then if there is a dearth of investment or partners willing to take up some of these research projects and work with them, then their own, the products that they could create for their own population, that's at stake as well. So I think a little bit of the responsibility also lies on what India can do for its own population. Now, what was the
last question was on the ability of your member companies to interact with the Indian government to try to find other avenues for addressing some of these concerns.
Yeah, I mean, I think our companies really do want to, especially the small and medium-sized companies that are looking for partners and investors. They do want to work and reach out to the Indian government or other governments that are willing to work with them. But I think that, they've gotten mixed signals and mixed reviews. I think the government has. They have reached out to the government. I think in certain instances they've been able to have conversations. Whether anything comes out of some of these conversations is unclear. But we have had an opportunity to meet with the Indian government as an association. We are trying to reach out to the new Indian ambassador. So I think we're still open to seeing what India is willing to do. But I think at this point we haven't seen anything that's shown that allows our companies to believe that there are going to be opportunities in India the way that they were several years ago.
We're at our 10 minutes, so unfortunately we're going to stop there. Thank you so much. There were some additional questions that the panel had, so we will submit those to you right in and request that you respond to them within the next 2 weeks. Thank you very much for joining us today. I'd like to call the next witness, the United States Chamber of Commerce.
Well, good afternoon. Hope everyone's doing well.
Welcome. Thank you for joining us. We're just making sure you have the right nameplate, although there's nobody photographing you from this. Well, yes, there is actually. Just a reminder, this is being videotaped and transcriptions being prepared, and all of that will be available within 2 weeks of the date of the hearing at ustr.gov. So thank you for joining us today. Please introduce yourself and spell your name.
Of course. Well, thank you.
Microphone, sorry. Thank you.
My name is Jasper McSlero. That's spelled Jasper. Last name McSlero, M-A-C, capital S-L-A-R-R-O-W. I am a fill-in for Mark Elliott, who was scheduled to testify from the U.S. Chamber today, but he grew ill over the weekend, and so he asked me to fill in. So I hope that's acceptable. As I said, my name is Jasper McSlero. I'm the Executive Director for Intellectual Property at the U.S. Chamber of Commerce's Global Intellectual Property Center. I want to thank you for the opportunity to testify and for your continued efforts to promote the importance of intellectual property worldwide. The GIPC, in cooperation with the U.S. Chamber's International Division, welcomed the opportunity to submit joint comments on this year's Special 301 review. Our submission highlights key improvements as well as challenges with regards to IP systems in 9 markets. It is important to note the critical role IP plays in creating jobs and spurring innovation. According to the U.S. Department of Commerce, U.S. IP industries account for $5 trillion of our nation's GDP, 60% of exports, and 40 million jobs. In short, IP drives knowledge economies. Robust IP rules and effective enforcement systems are an essential measure of the climate for companies that wish to conduct business with foreign countries. To that end, the Chamber recently released the 2014 edition of the International IP Index, which maps the IP environment of 25 countries around the world using 30 indicators. And we attached it to our testimony as well, and we've got some copies today if you're interested. The index covers patents, trademarks, copyrights, trade secrets, enforcement, and ratification of international treaties. The indicators used were developed in consultation with an academic researcher and industry sectors. The index measures specific provisions that industry sees as crucial to creating and maintaining an innovative business environment. It also includes global best practices defined by a number of international treaties. As I mentioned, we have submitted a copy of the index with our Special 301 submission for the record and refer to it where appropriate throughout the submission. Now, I would like to discuss a few global trends on the protection and, in many cases, the erosion of IP rights. Firstly, we are seeing an increase in laws and regulations that undermine IP rights, which is detrimental to innovation and economic growth. Examples include India's issuance of its first compulsory license to allow for the generic manufacturing of a patented anti-cancer drug, and Australia's legislation that stripped trademark owners of their ability to use their brand on tobacco products. Such actions establish a dangerous precedent for the protection of IP for all industries. Second is the importance of bilateral and regional trade agreements. The Chamber supports the negotiation, conclusion, and enforcement of all trade agreements that advance global IP standards. In particular, the ongoing Trans-Pacific Partnership negotiations, the TPP. Thirdly, while the Internet has developed into the greatest marketplace of goods and ideas, online IP theft is massive and growing. It is critical that law enforcement has the tools, the resources, and the will to fight theft in both the online and the physical environments. Fourth is the need to improve enforcement efforts and resources in the United States and overseas. In addition, it's important that the United States continues to work with foreign governments to promote bilateral enforcement efforts. And lastly, the Chamber is also particularly concerned about the transshipment of illicit goods including counterfeit products and the process by which these goods are destroyed and seized. In addition to these global trends, the GIPC submission also highlights specific country assessments. Over the last year, a number of countries have taken steps toward improving their IP systems by securing effective and transparent IP rules. For example, Canada recently concluded negotiations with the European Union on the Comprehensive Economic and Trade Agreement, CETA. Should the provisions of CETA successfully be implemented, Canada's IP environment would improve significantly. In China, we continue to see progress made to protect IP rights through certain amendments to their copyright, trademark, and patent laws, and in the recently concluded judicial interpretation on internet liability. Russia's new notice and takedown provisions with regard to the responsibilities of information intermediaries indicates progress in protecting copyrights. Malaysia introduced significant changes to its copyright laws as well. While a number of countries have taken positive steps toward improving their IP environments, some countries have taken steps backward that will stifle innovation and arrest the ability of creators and inventors to have their intellectual property protected. Some examples of this are India. Both the inaugural GIPC Index, which was produced in 2012, and the 2014 edition found that India ranked last overall behind countries such as Brazil, Russia, and well below China. In the past 2 years, the Indian government has demonstrated a pattern of behavior that caused a rapid deterioration of the IP environment, making India an outlier in the international community. And as the GIPC Index suggests, the IP issues in India are affecting a wide variety of industries. Within the biopharmaceutical industry, there have been a number of policy, regulatory, and legal decisions to revoke and deny patents. Notably, these patents are recognized elsewhere in the world, positioning India as the international outlier. India has an extensive copyright industry. However, the government's copyright legislation passed last year fails to adequately protect Indian and international creators and innovators. While the copyright legislation was much needed, this legislation contains many deficiencies that fall well short of the intended purpose of the legislation, which was to implement the WIPO Copyright Treaty. India is also a bad actor in multilateral negotiations. India is not participating in the ongoing negotiations to update the WTO Information Technology Agreement. At WIPO, India stalls discussions, openly accuses rights holders of abuses, focuses exclusively on exceptions and limitations, and has not signed on to treaties on copyrights. It has called for compulsory licenses for clean technologies before the United Nations and pushes other middle-income countries to support an anti-IP agenda at these institutions. It's important to note that the Chamber's submissions on the Special 301 have not previously recommended specific rankings of countries, but only highlighted concerns. However, given the rapidly deteriorating climate in India, we urge USTR to designate India as a priority foreign country in the 2014 Special 301 report. In Brazil, we are concerned that the Brazilian National Health Surveillance Agency is acting beyond its congressional mandate when reviewing patent requirements and applications filed with the Brazilian National Industrial Property Institute. We also note that there are several bills related to the internet and copyright protections that are being considered in Brazil. It's imperative that these initiatives not erode or limit the ability of rights holders to protect their IP. Canada's inadequate level of IP protection and enforcement continues to be worrisome. Our submission highlights recent decisions by the Canadian federal courts that have imposed an onerous test for utility, which is inconsistent with its legal precedent and international obligations. While we commend Canada for its passage of Bill C-11, we urge Canada to do more to combat IP theft, particularly online. We continue to have serious concerns about the size and scope of IP infringement in China, despite reported efforts by government agencies to clamp down on these problems. We also strongly urge the Chinese government to advance the development of new medicines, including through the establishment of effective regulatory data protection. We are concerned that the current proposed policies of the European Medicines Agency provide unrestricted access to and publish the clinical trial data and other confidential business information contained in regulatory submissions for marketing approval. These practices harm patient privacy, undermine the integrity of the regulatory system, and undermine incentives for innovation by allowing competitors to gain unfair commercial advantage over innovators. Such practices are also not consistent with the EU's obligation under the TRIPS agreement. A couple more. Our submission notes that Mexico's ability to combat the transshipment of pirated and counterfeit goods through its borders would be significantly enhanced by providing ex officio authority to its customs officials. We also urge Mexico to provide clarity that the June 2012 data protection guidelines also cover biologic medicines and to fully implement the WIPO Internet treaties. While Russia has made positive steps in 2010 by providing 6 years of regulatory data protection, there has been no implementation observed to date. Copyright piracy also continues to be a significant problem in Russia. Russia needs to amend its laws to provide effective copyright enforcement on the Internet, including modifying the civil code to create clear liability for acts that induce or promote infringement. Although there are laws and regulations in place that protect IP in Ukraine, implementation of these laws has been inconsistent. Piracy rates in Ukraine are among the highest in Europe. In order to curb this growing problem, we encourage USTR to work with Ukraine to increase enforcement in the markets identified in USTR's Notorious Markets Report. And while the Chamber welcomes some aspects of South Africa's draft national policy on an intellectual property, there are also elements that cause serious concern for industry. For example, the currently considered proposal states that developing countries can adopt IP policies that limit the extent of patenting and facilitate the introduction of generic competition. Further, the pharmaceutical patentability requirements included in the draft policy closely resemble that of Section 3D of India's Patent Act. Due to the rapid deterioration in India's IP environment,